The Law Report with Karen Key.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, being the second Monday of the month, it's time once again to open the lines for you to ask that legal question that doesn't quite fit into the other topics we discuss here on the Law Report. And just before we begin, a reminder that there's a list of available documents on the Facebook page, Law on SAFM. If you'd like any of them, post a message on Facebook, but please remember to include your email address, or if you don't have access to Facebook, you can email me on law@safm.co.za and I'll send you a copy of the list and you can choose what you want. And my computer, let me tell you, is now back in the land of the living, so I will be replying to you shortly. I've been without it now for quite a while. Well, I'm joined once again this evening by attorney Nicoline Schoeman-Low, and she's a director of Schoeman Law Inc., Conveyancers and Notaries Public. Nicoline, welcome back to the show. These months just seem to go by in a flash.
It seems like it.
Seems
Thank
like
you
you were
for
just
having
here
me.
yesterday.
Yes, but remember we
It
switched
was a
Monday,
short-
so maybe
okay,
that's why.
that makes me feel better now. I thought maybe all these load shedding things were starting to affect my brain. Okay. Well, if you've got any questions for us, you can call us on 0892 10 2010, 0892 10 2010. We've just got a couple of emails which we'll go through, quite short ones, and then we'll take your calls. But you can call us in the meantime and just leave your name and number, and we'll call you straight back as soon as we're done with these. Right, there's an anonymous one. It says, please ask the attorney, I'm assuming that's you, if one's parents can cede immovable property to one's child, does a document to cede supersede a will? And the parents in this case are married in community of property. They have primary residence. I'm assuming that they're not South African born. The dad has 12.5 share of a farm from his father, which is held in trust.
Okay, well, firstly, generally speaking, the answer is no. You cannot just cede a property to a child. There has to be a cause, as we call it in law, or a causa, as we more formally refer to it. In other words, you either sell or you give, in other words, donate, or something along those lines. And then, of course, you'll also do so by way of a contract or a document of some sort. So it is a very formalized process. You can't really just say, I cede this property to you without any documentation or a formal process being followed. So generally, the answer is no. But if there's been a document properly signed, then of course it may change the position as to the general one. So there needs to be some form of a transaction. The primary residence, in my understanding of this, bearing in mind that this email is written in a very verbatim form, would seem that there's a farm as well as a primary residence. So a house where the parents are currently living, primary residence. I don't think that necessarily means they're not resident in South Africa or South African residents or citizens. And then they've got this share in some farm which is held in a trust.
Oh, I see what you mean, primary residence. So they've got a house that's their
I would
only
say
house.
that this is the secondary property.
Oh, right, okay.
But maybe I'm misunderstanding.
I think I was wrong there.
The email is written in a very shorthand form, so maybe we're reading into this. But be that as it may, there needs to be a formal process followed in order for it to supersede a will. In other words, if you leave a property on your death to someone else, and there was no formal process, then the will direct what happens to the property. However, if you've signed some deed of sale or something and it's formalized and it goes through the deeds office process, then yes, it can supersede a will. So it really depends on really what process was followed here and if it was a formal one or not. But seemingly it hasn't been formally followed. So my answer would be that no, you can't just cede a property. And what further substantiates this opinion of mine is the fact that this property is held in a trust, which means the parents are no longer the owners of the property. The trust is the owner. And then, it further makes the situation a little more complicated. But in a nutshell, I would recommend to this listener to take all these documents and go and sit with someone, show them exactly what you're talking about, go through all the formalities, all the documents, and get a proper legal opinion. At this stage, we can only say the general rule says no, but there are two variables at least that I've mentioned that could change the position.
Now, this listener who wanted to be anonymous is listening, and we have got the story totally wrong. please do call in on 0892 10 20 10. You can stay anonymous, but if you'd like to add anything to that, or you'd like to explain a little bit more,
Yes.
because we maybe don't have the full story here, please feel free to call in, and we'll continue that. The next one is the most awful one.
Yes.
It's from Stavrula and says, my mother's an Alzheimer's patient and she stays in a home. Last week she was pushed by a member of staff at the home and sustained a number of bruises on the forehead, face and broken teeth as well. The people in charge didn't help her. I saw her injuries later on when I visited and was told by a nurse that she fell, but another nurse said that she was pushed. Can I sue the home?
Yes, of course you can. But the bigger question, rather than can you sue, is can you prove fault? And generally speaking, that's the most challenging part, because many of the staff would come forward and be honest about the situation, but similarly many of them may not. So it's really about the integrity of the evidence that you would be able to collect in a situation like that. I would recommend that this listener also approaches a specialist personal injury attorney who can deal with this process of negligence and, of course, assault.
The awful thing to say to people, but if this, heaven forbid, happens to somebody in your family, take a picture. So
Yes.
you've got some sort of photographic evidence of,
Yes.
as you say, your mother was bruised,
And
the broken teeth. Take a picture. Or take a
Exactly.
number of pictures.
Take a number of pictures, take the details of the person who was willing to come forward, maybe get a bit of a statement out of them. Get the ball rolling as soon as possible. The longer you leave this kind of thing, the more hazy the memory becomes, and the more your integrity of the evidence involved becomes tainted, for lack of a better word.
Right, we just have a couple more emails, so if you want to call in now, you can do so. 0892 10 20 10, 0892 10 20 10, and we'll call you back shortly. Right, the next one is from Mel, who says, can a bank sue you for service fees if your account is dormant?
Well, it depends on the terms and conditions that you signed when you applied for your bank account. I mean, they always, when they deliver your banking card to you, have this piece of paper with all the columns printed on it, and it's
How many
back
of us
to
have actually
front.
read that? I mean, seriously.
That's the problem. We don't read that. And once something like this happens, then we ask these questions, and the answer really lies in those documents. Of course, one can argue it with the Consumer Commission, or even the Banking Ombud for that matter, to say that what service has been provided if there's no activity on my account, and see if you can argue it from there. If you're unhappy with any fees that have been charged, then of course withdraw the money or defend the court action that they are purportedly taking. But in a nutshell, the answer really lies in the paperwork that you would have signed when you opened the account in the first place. If you're unhappy about it, either defend the court action if they are actually suing you and it's not just a letter of demand. If it's just a letter of demand, then you can still refer it to the Banking Ombud if you are unhappy about the charges.
And just to be difficult, I often wonder about bank charges in general when I'm doing all the work. I mean, I'm the one doing the internet banking or going to the ATM or, by myself.
It's the same argument as the safety deposit boxes that
Which
we
is
used
sitting
to
there.
have, where you would just put something in there and essentially you're paying for storage. Now, the bank in many instances has followed the same line of argument to say, but you're using my facility. It's your choice if you don't want to be active with the facility. If you don't want it here, then draw the money out and put it in a piggy bank box under your bed or in your mattress. And that's sort of their line of thought. Whether or not you can successfully argue against that will remain something to be seen.
Yeah, it's a good point. I mean, Mel, if you ever get this right, do please let us know what happened. I'd like to know.
Definitely.
Right, Susan says, is insurance on guests' belongings necessary by law in the hospitality industry if there is an indemnity sign?
Well, it's not just confined to the hospitality industry. I mean, it's even your spa facilities, anywhere where or gym facilities for that matter, where you are storing some of your personal belongings in a box or similar facility within the business, then you usually sign some form of indemnity, or they put up signs that they're not responsible for what happens to your goods during your stay there. So it's a fairly general a fairly general indemnity that you have to give as a guest, whether it's at a health club or something else, or hotel or restaurant, or whatever the case may be. And it's only proper to take out some insurance in order for the business or the restaurant, as I presume this may be your hotel, to cover any potential risks that they may be carrying if one of their staff members were perhaps either at fault for the goods going missing in the first place, or of course the instance of negligence, where someone, should have attended to a jacket, for example, that you leave at entering a restaurant, and that person just didn't do that. So of course the establishment should also guard against the risks their employees or things that are in their direct control would actually pose. So it really depends on the circumstances of what happened here. I had a client not too long ago with a similar situation where one of their employees actually was tasked to look after the goods of visitors while they were busy doing some sightseeing and all sorts of things. And someone just didn't watch properly, and someone came by and stole a handbag. And, from the business's perspective, you need to decide whether you are going to refuse to reimburse this customer and run the risk of a Hello Peter listing or something along those lines, or, heaven forbid, a claim, versus actually taking out the insurance in addition to this indemnity. So it really depends on why or what went wrong, and whether or not the business involved could be held accountable. And if they can, then it's really their business where they get the money. If they don't have the insurance, it's really not the customer's problem, for lack of putting it differently.
Let me tell you what happened to me today. I went to the paint shop to go and buy some stuff. And I pulled into the parking area, and right where you have to park was this massive, it was vast, metal sign. It was standing on like leg things, and it was advertising the shop. And so that's how you knew that the shop was there. It was because there was this big sign. But you had to park right in front of the sign. And there was a big thing painted at the bottom of the sign that said, you park in front of the sign at your own risk. Now, what are you supposed to do? There's nowhere else to park.
Exactly.
So what do? The gust of wind comes up, the sign topples over and smashes your car. And they said, well, we did say you could park there at your own risk.
It goes back to a discussion we had on the law report a couple of months ago, if I'm not mistaken, about signs that get put up in parking lots and shops, limiting the business's liability should anything go wrong, should you fall, should your car get stolen, and all of that. Those signs are not a get-out-of-jail-free card, so to speak. Those signs have their limitations. If there's negligence or fault on the part of the business, for example, let's take your sign. We live in Cape Town. We know it's a pretty windy place to live in. So if that sign is not reasonably secured with maybe bolts or something, and it blows over, it's just loose standing. Even if you've put a sign on there, in my view, there's a very clear element of gross negligence.
Well, if I go back there and it falls on my car, I'm phoning you.
Totally.
We've just got one more email to do, and then we'll be taking your calls. I see there's quite a list already on the screen. Right, this is from Rob. He says, I bought a pre-owned Mercedes C200K with almost 100,000 Ks on the clock from a reputable dealer in Umhlanga. Within 6 months of buying the car, the engine practically self-destructed due to an apparent known problem with these engines, in that the timing chain stretches, which wears out the cogs the chain runs on, and which eventually failed completely while I was driving, causing the engine to destroy itself. I've had to buy a second-hand engine and have it installed. The dealership accepts no responsibility, and I'm currently 60,000 Rand poorer. My question is, do I have any legal recourse in this matter? This happened when I'd had the car for under 6 months.
Well, in terms of the Consumer Protection Act, everything that you sell should be of a reasonable quality for at least a period of 6 months from purchase or delivery, whichever comes later.
Even though it's a second-hand car.
Now, the problem, that's what I was going to say now. With second-hand goods, it's a little more complicated than that. So if it's a reputable dealership, it's not Joe Serp on the corner of, then you'll have a better chance if referring this to the Consumer Commission to actually get some
recourse.
To get some recourse. In addition, you also have your industry-specific ombuds, your motor industry-specific ombuds, which you can also approach, and they are quite efficient. So either Consumer Protection Act, Consumer Commission, or one of these industry-specific ombud structures. It's also good to approach an attorney to address a letter to this dealership and see if it can be resolved without going the extra step. And if that fails, first try and report it to the ombud structures, because it would be more cost effective from that perspective. Because
he says the dealership's accepting no responsibility, so he's obviously made some sort of an approach to them,
Yeah, so maybe if they get an attorney's letter, they'll take it a little more seriously, because many of these guys feel that, what are you going to do about it? I hear you are upset, and they're not really customer service oriented, and it's not really a motor industry specific situation. We've seen it all over happening, where people just will not be accountable for their actions. And of course, if it depends on the contract that you signed. If you've signed a clause that says that they don't take any responsibility, they don't guarantee any faults and all of that, then again,
but is that legal to put into a contract though?
You have to disclose any defects. You may not misrepresent a situation and say this is in a good condition. Fits to it, as we used to know it, just to add to that, isn't a one-size-fits-all solution anymore, or a get-out-of-jail-free card.
Because he says that the problem started with an apparent known problem with these engines. So I would assume that the dealer would have known that these types of engines have this problem.
And if he can
if
prove
they didn't
that,
warn him about it, then he's got a case, surely.
Of course, if he can prove that. Often, you'll take these kind of situations to, let's say, the manufacturer, and they'll say, but we had issues of factory related issues with these models or whatever, but if they can prove that all their dealers knew about this and there was a circular, then of course it strengthens your case. Otherwise, these guys are just going to say, here are the reports that we ran, it was never an accident, it isn't a stolen vehicle, it was roadworthy. And that's really the three main tests that you have at your disposal if you're buying a used vehicle or a pre-owned vehicle, as they put it. You get your criminal record report, in other words, whether it's a stolen vehicle or not. Secondly, you get your roadworthiness certificate, which just proves that the car is in a good working condition and compliant with all the regulations that it needs to be in. And the damage or accident report. And if those three things come clean, it does, unfortunately, in my experience, not safeguard you from a situation.
So basically,
like
I think, Rob, you need to pretend you're Sherlock Holmes at this point and
Yes.
investigate whether this is, you say here it's an apparent known problem. You need to try and find out if the dealers were made aware of this problem, if they have this problem on record and they just didn't tell you about this problem. You need to go and find out all that sort of Sherlock Holmesy type stuff.
Yes.
And that's going to really strengthen your case.
Of course, and then go to the ombud structures. I would recommend and go and see an attorney. It can't hurt. Maybe in some instances, one letter solves it all, and that's where it ends. So it's probably worth the try.
Worth a shot. Right, let's get stuck into these calls. There's loads of them. Nombulelo in Kimberley, good evening.
Hi, Karen.
Hi,
Thanks
hello.
for a great show.
Thank you.
Karen, I
Yes.
just want to find out about the COIDA, Compensation for Occupational Injuries and Diseases Act. I understand the act was first drawn up in 1993 and then was amended in 1997. Now, the version that I read in 1993 says that domestic workers, policemen, people in the military are excluded from any compensation. Is that true?
Is this something that you would be comfortable talking about, Nicolene, or is this more of Michael's?
This is actually more of a Michael Bagram situation.
Nombulelo,
problem.
we've got your number. What I'm going to do, Michael Bagram, who is our labour law attorney, who comes on the first Monday of every month, I'm going to keep your number. And may we call you when Michael's on the 2nd of March?
Yes. Yes.
And we will call you, and then you can talk directly to Michael, because this is really the kind of thing that he specialises in.
Thank you.
All right, so we'll call you back then. Thanks, Nombulelo.
Right.
Thanks. Before we go any further, let me just mention we're not doing property or labour law. That's not something, because we've got specialists in those fields.
No,
so
definitely. And
property and labour.
All I can say about the inquiry that we just had is that, in generally speaking, your Labour Relations Act, Basic Conditions of Employment, and COIDA, as listener just mentioned, do exclude people from the National Defence Force, police services, and so on. It's always been the case. And the reason for that is that those relevant pieces of legislation actually make similar provision for those employees within those fields of employment. So, and that's just off the bat general labour law advice.
Okay, but we'll call Nombulelo back when Michael's here and
Yes,
she can chat with him.
Definitely.
Right. Mpongi and Cristiano, good evening.
Good evening, how are you?
Hello, fine, how are you?
I'm okay. Can I ask you a simple question?
Sure, go ahead.
Yes, look, I want to know if money won in lottery game or any form of a gambling and the royalties and after writing, say, a book form part of a joint estate, and then what are the other examples that can be cited as examples of assets that are excluded in a regime of married in community of property?
Okay, well, generally speaking, if your gambling winnings have been paid out, then it forms part of the winner's estate. So, and in terms of the marriage in community of property, you share everything, profit and loss. It's actually the full name of the marriage in community of property is the marriage in community of property and loss. Profit and loss, in other words. So whatever you achieve or get in your lifetime, on whatever debts you incur, you share with your spouse equally. 50-50. The only exceptions to the general rule is if you get a gift that is excluded from the property regime. So let's say your spouse, his or her parents pass away and they leave a property to that person, and then they exclude it from the marriage in community of property. So donations and also damages claims, if let's take the example we had on our emails earlier, where there was abuse in the home of an elderly person. If that person was to bring a application to court for damages against that home, any damages that would be awarded is also excluded from the marriage. So donations, gifts in other words, inheritances, and damages claims. Everything else, 50-50.
So Mpongi was asking about royalties from a book and from gambling winnings.
A book,
all half
of
for
that.
50-50, everything.
Yes.
Is that not good news, Mpongi?
But regarding lottery, I wanted to know if it is it actually legislated, or is it the interpretation made by you legal people that even lottery, is it there in the same Marriage Act or whatsoever?
In the Marriage Act, it actually defines the exceptions, and everything else is defined as being included. And as I mentioned, the three exceptions: inheritances, donations, and damages claims. Those are the three exceptions. Everything else by law is included within the ambit.
Money won in lottery would be classified as...
It's not expressly excluded. I can't think of any court cases that have been brought to court around this. I'm sure if one does a bit of research, you can get to the bottom of it, whether someone else has maybe taken this to court. But until someone has challenged for whatever reason that this is unfair, as the lawmaker has prescribed it, I can't advise you that lottery is excluded from that. I can't see a legal basis. Maybe if there's a court case out there, it may change my opinion. But the marital property regime and related legislation is very clear.
Mm-hmm.
Yeah.
Thank you very much. I'm answered.
Thanks,
Okay.
Mpongi. Good night to you.
Bye.
Right, off to Cape Town now. Sharon, good evening.
Good evening.
Hello, how can we help you, Sharon?
Hi.
Hi, you there?
Hear me?
Okay, hello. Yes, we can now. Hi.
Okay. My dad passed away 2 years ago.
Mm-hmm.
On his retirement, he invested his funds.
Mm-hmm.
And this week, the guy that was supposed to invest the money paid it back into my account without interest. my understanding was when my dad invested with him, he would invest it at a certain percentage of interest. Now, 15 years later, he pays me out the capital without the interest. Is there recourse that I have?
Oh my word! Tell me, who did you approach to make this investment? Is it a broker? Did he work for a company?
I think the guy that my dad invested with was a broker.
Okay, well, if it's a properly registered broker, you can actually approach the Financial Services Ombud and actually institute a complaint against this person. Particularly, and we see this often in investments like what is often commonly referred to as property syndications. Yes. So you have someone who tells you, oh, they've got this great property portfolio, and you'll be investing in all these properties that are located around the peninsula or wherever it may be. Actually, it doesn't really matter. And you really can't lose on this investment, and it's properly registered and all these things. But what they don't tell you is once you give, it's like really extending a loan to a small business, because they use your funds to buy these properties and to bond them and all of that. And if you want out, depending on how much you've actually invested in it, you may actually find yourself in a precarious position in order to get out. Because if 10 people at the same time want to get out, they don't actually have the cash flow to buy you out.
So now, 15 years later, he only paid me the capital without interest.
Sharon, was at any point during your father's life over those 15 years, was he getting any monthly income from this money?
For the first 4 months of the 15 months.
No,
you 15 years.
You need to, besides what this is, obviously, I mean, if you do the calculations, it's not just a case of not earning any interest. You haven't even beat inflation for 15 years. If you got your capital back 15 years down the line, you've actually
lost.
If you do the math, you'll see that he's actually lost all his money from that perspective. So
which ombudsman is
Financial Services Ombudsman.
Okay,
remember, they only have jurisdiction, though, if the broker is properly registered. In other words, with those FSB numbers.
Yes.
If he has any of that on his letterhead, then the Financial Services Ombud will be able to assist you. If not, you'll have to take this person to court. Do
you have any correspondence from him, Sharon?
None whatsoever. Somebody phoned me and asked me to contact him, give him my banking details, and he refunded me the money into my bank account.
No,
so all I've got is the name and a telephone number. Nothing else.
Now, you need to do a bit of an investigation and don't wait too long. Go and see an attorney and get the ball rolling on this. I mean, I presume your father is elderly.
No, he passed away 2 years ago.
Already passed away. Sorry, my mistake.
Yeah.
So, I mean, this is completely unacceptable.
Thank you very much.
Financial Services Ombud, Sharon.
Yes, no,
they're very useful.
Okay.
So just Google it, and they're very, very efficient. I must say, I've had good experiences. They tackle things head on.
Appreciate your help.
Good luck, Sharon.
Righto.
Bye now.
Bye.
God, that's really awful. It really freaks me out, those stories.
Exactly, and these guys often sell you these products, best investment ever. And often when you hear capital was only repaid but no interest, then it's often a semi-structured investment that it leads people to believe that it's such a well-performing investment, while it's actually nothing better than investing into a small business in terms of a risk that you'll be carrying. And elderly people shouldn't be investing in things like this. I mean, there's a lot of articles on the internet very much against this. Please don't invest in any of these non-registered or high risk. If you're getting
it sounds
so much
too good to be true, trust me, it probably is.
Exactly.
If you're telling you're going to get 20% interest every 6 months or something, no,
the bell should
happen,
go on. Unfortunately, rather get a second opinion before you give these oaks any money.
Right. If you have any questions, we've just got a few more calls lined up. The number is 0892 10 2010. 0892 10 2010. Fran in Johannesburg, good evening.
Yes, hi.
Hello.
I have a question regarding load shedding
Oh, yes, I've got lots of questions, Fran.
and banking. What happens if you're in the middle of a transaction on the internet and your electricity disappears and possibly some of your money into the bargain? Obviously, it's neither the bank's fault nor your fault.
Yeah, I think we've actually had a similar inquiry at the office today, more insurance related though, but the banks are saying that they're taking precautions that these kind of things can't happen. So your banking profile should, or your banking provider should at least guarantee that you've got a stable platform to work on in load shedding. But of course, if they don't do that, they'll just pass the onus back to you, saying that you could also have bought a UPS for your computer and all these things that could keep the power running while you can finish your transaction. So unfortunately, in my view, practically these things will be a blame game until someone has taken this to court. Taking Eskom to court as a result of that.
Not a chance.
I mean, you and quite a few people would be doing the same. So at this point in time, I would rather advise to be proactive. If you are really engaging in these transactions on a regular basis, invest in one of these batteries, UPS systems, in other words, for your
Uninterrupted
computer.
power supply, basically.
Yes. Or I know many people are actually installing generators at their homes.
Or be like me and just have a list of all the power outage times. Then you hook up. It's a whole performance. I've got the schedule. Then I'm on the City of Cape Town's Twitter alert, where they alert you every time the power's going to go down in whichever area.
Yes.
Then I check on my schedule. It's not me. But when I see it is me, half an hour before it's supposed to go off, I switch everything off. So that I'm not going to be caught unaware at the last minute.
Exactly.
So I'm now being overly neurotic. So half the time I can't work on my computer because it's permanently almost switched off. So
and I know also
when it's not blowing up and losing everything,
Exactly, and I know besides the UPS systems, many people are watching their schedules. Of course, if you have, I know nationally we don't have schedules being followed accurately.
No, we don't.
But at least make sure that all your electronics are charged that are battery operated. So if you're using a laptop, make sure that it's always charged. At this stage, we're charging it like the cell phone, to make sure that we've got a little bit of battery to carry you through if you're doing a transaction or something like that. So unfortunately, I'm sorry that I don't have such good news, but I think for now, one will have to be proactive in order to limit your risk. Until someone takes this to court, someone who suffered a big loss or is willing to get a bunch of people together to see whose fault this really is.
Do you have relatively stable schedules in Joburg, Fran? I just know in Cape Town ours are pretty stable.
No.
Oh.
And we're thinking of paying some airline tickets, but I think we'll find an office to go and pay them at.
And that might be safer.
Yes. Thank you for the advice.
Good luck.
All the best.
And enjoy your trip wherever you're going, where hopefully there's power.
Thank you.
Okay, thanks, Fran. But I'm almost quite jealous now. She's going away somewhere and they've got electricity. That's not fair. Right, let's stay in the Western Cape. Robert, good evening.
Good evening, Karen, and thank you for the nice program.
Pleasure. How can we help you, Robert?
Please unbundle this one for me. I wish to just apologize up front. I only heard after I had logged my call that you guys are not doing any property-related, labor relations related stuff.
No.
But then mine could be a different case, and you can just guide me on that one.
Okay.
I live in a sectional title community where my levy account was handed over, and we were summoned for that. And so the legal processes that have to do with that action of the body corporate against us, they are underway. However, when the summons arrived, we then decided to go to the chairperson of the body corporate to say, look, this is too antagonistic. Can't we just sit down and talk about this? in the process of trying to talk to the body corporate via the chairperson, they knew that we only had 10 days to declare our intent to defend, and so they strung us along. And long story short, when our time to do that lapsed, they went. Their attorneys went and they drew a default judgment against us, which we have already dealt with. Now, the issue here is in the process. I need a copy of the conduct rules. Our bin got stolen, and we cannot deal with the municipality directly because the municipality says that the chairperson of the body corporate needs to sign a form and do whatever. When we contacted the body corporate, they say to us they were advised by their attorneys that until our case has been resolved, we need to communicate directly via their attorneys or via our attorneys. Now, something like a bin, why do I have to contact the attorneys of the body corporate to get a replacement refuse bin that has been stolen? Why do I need to contact the attorneys of the body corporate to get conduct rules that I need on a day-to-day in order to safeguard my visitors and everyone else who is related to my unit, that they don't become a nuisance to the body corporate? So it is that type of a situation. I don't know if this will draw me any help from you tonight.
Well, okay, I'll just ask you, whereabouts in the Western Cape are you?
In Belleville.
Okay, well, let me tell you what happens where I live, which is in the southern suburbs of Cape Town. If one of our dustbins gets stolen, all you need to do is go to the police station. You need to get an affidavit from the police station to say that you had the bin was stolen. They'll give you a case number, and the city council, all they need is that case number from the police station to issue you with a free bin.
I did that. I did that. I went through that entire jazz, and only when I got to the consultant at the Belleville municipality, she said, "Oh my goodness, you live in a sectional title community and you don't have an individual account because your account is bundled into all other accounts. So it is a body corporate. So the chairperson of the body corporate is responsible for that. But I can tell you, for 2 months going now, he hasn't answered any of my emails. He doesn't return my calls. He doesn't return my SMSs. So I basically have to live in filth."
Yeah, and Robert, just as a matter of interest, the show next week, I'm planning it's purely on sectional title because I've had so many calls about sectional title issues that we're going to purely be focusing on sectional title next week.
But are they within any legal right to tell me that whatever my needs are right now are related? Is it possible? Is such a thing actually legal?
Well, usually when an account gets handed over to an attorney for collection, then the parties no longer speak to each other directly, so that it prevents any instance of miscommunication or errors in communication. For example, I think you've illustrated an error that could have resulted from speaking to the chairman directly versus speaking to an attorney or the attorney. The attorney didn't know you've made some arrangement with the chairperson, and now they've gone ahead and still taken the judgment against you. And really, that is why they say once a matter has been handed over, you need to channel all your correspondence through that attorney. It does seem a little silly to me that they are blanketing this as all correspondence, wanting conduct rules, this more, call it administrative domestic bin issue. I think that's taking it slightly too far in my opinion. I also deal with quite a few sectional title disputes on any given day in our practice, and we don't get involved in the administration. That's why the managing agents of your complex are there. They are there to give you a copy of the conduct rules. Whether or not your levy account is paid up is quite irrelevant. You as a co-owner has a constitutional right to getting a copy of the conduct rules. The issue of issuing a bin and all of that, similarly, that's got very little to do with your outstanding levy issue. So for me, it's sort of like making a fruit salad here, where you're saying, not apples for apples, but apples for pears. You're comparing two unrelated issues with one another. So personally, I do agree with you. I think it's slightly silly that you're being asked to work through the attorney. But, at this point, until you've managed to resolve the issue of the unpaid levy, it's probably the way that they are going to steer it.
The judgment, for your information, has been successfully rescinded, and when the matter was set down for court, their attorneys did not pitch, even the trustees themselves did not pitch, because they knew that they didn't have a case. It's a symbolic thing. I don't want to get into that, but the thing is, I'm at a cul-de-sac here. They are not willing to engage me or to speak to me on any platform. What do I do?
I would suggest if the judgment has been rescinded or removed, that you get your own attorney to write to them to demand the information, and if they fail to do so, that they bring a court application to compel them to do so. That's the only, unfortunately, it's always fairly unpleasant when it gets to that point, because you are all co-owners and you have to be neighborly to a certain degree. But sometimes it just unfortunately gets to a point where even if the other side has been wrong in what they've done, it gets to this point. So my advice to you would be to stop asking and now take some drastic action. Draw the line in the sand, as they say. And good luck.
Good luck, Robert.
Thank you very much.
Good luck. Doesn't sound like a very pleasant situation, but
especially not so close to home, hey?
No, absolutely not. Right, off to East London. Tamsankwa, good evening.
Good evening, madam.
Hello, how can we help you?
Madam, we divorced with my wife. Now, the papers says that I must get 50%, and now she is refusing. She says that she must get the lot, all of her pensions, because I was not working for a long time. She was the person who was doing everything. Now she must get all of his money. But the paper says that 50% is mine, 50% is hers. And now she's threatening somebody's life between me and her. Somebody's going to lose life. What can I do?
Oh, not pleasant.
Totally not. In this instance, you can always, it sounds to me that there's some serious threats being made. And firstly, to get a protection order, to make sure that you have some protection against anyone that could be sent to assault you or cause any other form of harm. That's, I think, the first and the most important. Then the second option is obviously to get an attorney and to enforce what the papers say. And usually what happens with pension is the divorce order gets sent to the pension provider, so the pension fund in other words, and they then make a note on her pension, and when it is payable you get your half. Many funds don't actually pay at date of divorce, they only pay when the pension falls due. So it's if you've got your court order, your papers in other words, it's fairly simple to go to the pension fund, give them a copy of the paper, and they do the necessary on the pension fund. And when the payment happens, half will be paid to her and half will be paid to you. You don't have to go in and collect it or anything like that.
And unfortunately, I mean, he's saying that she says that he wasn't working for a while and she was working.
That's irrelevant.
It's irrelevant because, I mean, often if you turn it around, often people get divorced and then the husband will say, well, she was a stay-at-home mother. I was the one that was working. Sorry.
Yeah. If
community
the court
property, it's half,
and
if that's what it orders.
And if the court order has substantiated that even further, then she must pay regardless of how she feels about it. Just be careful.
Tamsankwa, yes, your first order is to go and get yourself a protection order.
Yes.
Where would he go to get this? Obviously, I'm assuming not at too much expense.
No, you can actually go to the family court. and they're very helpful with protection orders. They help you fill it in and do all the necessary documents at the courthouse. And then, of course, the enforcing the pension, you can also approach...
Enforcing a whole 50% of everything.
Yes.
Where would you go for that?
Obviously, you can either try and do it yourself, but that may not be the best way of doing it. Legal aid, or of course, if legal aid can't assist for whatever reason, the Law Society, that someone can be appointed on a free basis, a pro bono basis.
Tamsanko, does that help you at all?
Okay, thank you.
And
All
good
the
luck
best.
with that. But your most important thing, go and get yourself some protection. It doesn't sound very good.
Yes, madam.
Okay, look after yourself. Be careful, huh?
Thank you very much.
Okay, good luck. Thanks, Tamsanko.
Bye-bye.
Good night. Bye-bye. Oh, no, I don't like hearing stories like that. Right, Mdu in Durban, good evening.
Good evening, ladies.
Hello, how can we help you, Mdu?
Okay, I just want to find out something. I have a female colleague here. She was under learnership from 2007 in August, and she got employed last year in June. And she had to go she gave birth earlier this year, but now the company is saying that she can't go on maternity leave. I just want to find out, is it correct? Because they're saying it because she just got employed she has finished about 12 months working for the company, so she can be able to get a maternity leave with pay.
Well, it
pay.
It depends.
Yeah.
In terms of law, no woman, regardless of what position you fulfill, is entitled to payment for maternity leave. But you are entitled to the time off. Okay, that's non-negotiable. It's just about the payment. Now, some companies, especially those with a lot of female employees, have special policies in place where they'll say, if you've been with us for X amount of time, we'll pay X amount of money for your maternity leave, whether it's a portion or whether it's full pay or whatever the case may be. And I have seen that many companies actually go one step further and say, if you go on maternity leave and you don't come back, then we will claim the money that we've paid for the maternity leave back from.
But now, what about unemployment? How long do you have to work before you can claim maternity benefits from unemployment?
I actually, because I don't work with the labor law,
But it's quite a while.
on every day. I want to say it's 6 months, but I stand to be corrected. I haven't actually, none of my employees even have gone on maternity leave in quite a while, so I'm very outdated when it comes to how these regulations work.
How long was she working for the company before she went on maternity leave?
She was under learnership from 2003 in August, and she got absorbed to be permanent in June last year. So she was contributing on UIF from 2013.
Okay, now then she could claim.
Then I'm quite sure that it may even be less than 6 months. I mean, it may be 4 months or so on.
Whatever, but she can claim unemployment. She can claim maternity benefits from the unemployment fund.
And I would recommend that she does that, yes.
But there's no law that says the company has to pay them anything.
No, so
unfortunately,
you will be guided by the company's internal regulations. And as I say, if they have set the trend, or even as much as written an email to her saying that we will pay X amount on these terms, then that's good enough to demand payment. But if nothing was said, then unfortunately the law doesn't protect you in terms of the payment of maternity leave.
But what about the contribution that she made on the UIF?
She can claim that.
She can still claim that, regardless of what she does.
No, but hang on, wait. When did she go on maternity leave?
She didn't go because she didn't go for maternity leave because they told her that if she goes, they won't pay her.
So she had the baby and then took 1 or 2 days off, or what?
Yes,
that's
maybe
horrible.
I think 1 week.
No.
But when was that, Mdu?
Earlier
It was
this year.
early in January.
Of this year?
Yes.
Okay.
Yes.
So, I mean, that's unlawful.
But can she?
That's
What he wants to know
completely unlawful.
now that she's back at work, can she still claim the unemployment? No.
Unfortunately not, but she's entitled. If I were her, I would demand my leave and go home and bond with my child. The law is very clear. You have to let your pregnant employee go.
But she chose not to go because they weren't going to pay her. which is why she didn't take it. So you can't really, it's not the company's fault.
it
She
depends.
chose not to, and by law, the company doesn't have to, sadly.
Yeah, but remember, there's a statutory obligation on you as the company not to let anyone that is pregnant for 4 weeks before giving birth until 4 weeks after to not work for you. It's like having a minor child, a 15-year-old or under, working for you. Even if they consent to it, it's unlawful consent. So regardless of the payment, she is entitled to the time off 4 weeks before birth at the very least. That's the statutory minimum, where you're not allowed to allow a pregnant woman to work for you anymore until 4 weeks after she's given birth, if there were no complications, of course. But a total of 4 months you're entitled to in terms of the law. So even if she consented to stay, the law is very clear in that regard. And that's nothing to do with the payment, it's just about the time off.
Because
And of course now, if it's in January,
before she gave birth, she
Yes.
was taken from her workplace because they had to phone the ambulance
sure.
to take her to the hospital.
I mean, something could have, the fact of the matter is something could have gone very wrong. She could have been very hurt. There's a reason for the 4-week rule, as we put it. 4 weeks before giving birth, things can go wrong, complications can happen. You have no business being at work anymore. And similarly, just after, there's medical reasons for these things. So, if it's more than 4 weeks, then much to do about nothing, I'm afraid at this point. But she is entitled to the time off, and maybe if she doesn't want to do anything about it now, it's just maybe it's time to look elsewhere for employment.
Oh, okay. All right. Thank you very much.
Okay, do. Thank you. Good night. Right. Paul in King Williamstown, if you can be very brief because we're running out of time. Good evening to you.
Hello, madam.
Hello.
Yes, I never read the contract of the employment properly, but I worked for a company where we sell products out of a vehicle and deliver them. So it's highly risky and dangerous because it's high-value goods. Then number of incidents take place, hijackings, armed robberies, all the things like that. The company did provide psychological support. However, the psychologist said to me that I'm ill, post-traumatic something. And then an incident occurred at the employment. I then resigned. However, my medical aid doesn't cover the psychologist now. So now, do I have a case to ask the company to pay for my treatment, or to pay because, let's say, I can't continue working until I get well, because she put me under 6 months treatment and then I resigned before that. So do I have a case? But I never read the contract. We were told before the employment is highly dangerous.
Okay.
Thank you, madam.
Thanks, Paul.
This is a difficult situation, especially if there's no contract in place and you consented, you knew it was high risk and all of that. But, at the very least, it's worth a try to see if they would be able to...
Because working for them is what's caused his PTSD, this post-traumatic stress disorder that he's talking about, yes.
No, definitely. But what company policy is in regards to the payment, and if they don't want to pay, taking them to labour court and all of that may be quite challenging. But I'm not convinced that it's a complete open and shut case to either side. So maybe it's good if one can get Michael's input on this.
Paul, we're doing a purely on labour law on the Monday, the 2nd of March.
All right.
When we have Michael Bagram in the studio. I've got your name and we've got your number. And what we'll do, Paul, if it's okay with you, we'll call you that evening and then you can talk to Michael Bagram because he is a labour lawyer.
Yes.
And I'll read the contract and then I can explain better to him.
Yeah, I think so.
Thanks for your time.
Okay. Thanks, Paul.
All the best.
Thanks. All the best. Good night to you. Right. We've got a minute and a half, so we don't really have time. Unfortunately, Robin, I do apologise. We don't have time to take your call. We've really, really run out of time. We always need like an extra half an hour on these law programs. They just
seems so.
Yeah, we do. We never seem to be able to quite have enough time. But Robin, you do have my email address. It's law@safm.co.za, and if you need to, just drop me a mail to that, and we'll see if we can help you out, seeing as you couldn't get through to us tonight. Also, the Facebook page is Law on SAFM, so have a look at that. All the information is there as well. Right, so another month and then I'll tell you that you were here yesterday again. So it seems to go by so fast. But thank you so much once again for joining me.
Well, thank you for having me, and hopefully we've helped a few people and answered a few questions.
There's been some awful stories tonight, but hopefully there's
Yeah.
good outcomes. My thanks once again this evening to Nicoline Skuman-Loan. She's the director of Skuman Law Inc., Conveyancers and Notaries Public, practicing here in Cape Town. She's been my guest on tonight's edition of the Law Report programme, and we'll be running legal clinics like this one on the second Monday of every month, and Nicoline will be back with us again for another law clinic on Monday the 9th of March. The Law Report is on the air on SAFM every Monday evening between 9 and 10. And a reminder again, there's a list of available documents on the Facebook page, Law on SAFM, or email me on law@safm.co.za.